not present at court for the continuation of the judgment on conviction. The date arranged between counsel is the 5th of June 2026 for continuation of judgment. You are to remain in custody.
Support, please. I also call the matter case number SS14 of 2026, a matter between the state and Mlungisi Glodlaw. I confirm my appearance on behalf of the state, my lord.
This was a pre-trial.
That's correct, my lord.
Yes.
My lord, I'm standing in for Mr. Musaba.
My lord, on the previous occasion, the matter was set down or postponed until today for purposes of pre-trial hearing. On the previous occasion, I indicated to the court that the DNA results were ready, that the analyst just had to compile the report. I was in constant communication with the analysts, and the report was signed, and because it first had to be checked and double-checked and signed. This was done on the 30th of April. I requested the analysts at the forensic laboratory to forward the report as a matter of urgency. I, however, only received the report yesterday during the course of the day. I am in the process of finalizing the Section 220 admissions. They are finalized except for the results of the DNA analysis that has to be added to it. It is thus my request that the matter be postponed to the 14th of May, that is next week, Thursday, for the purposes of the pre-trial hearing. I will forward the finalized admissions, proposed admissions, to both Mr. Musekwa and Mr. Mavata, and that will be done today still. Mr. Mavata indicated to me that the office would like to go through the documentation first, and they will probably arrange to see the accused before the pre-trial hearing in prison. So I will do this, I will undertake to comply with my responsibilities today. He is in custody, my lord, no bail.
The date, my lord, is suitable.
Documentation in respect of the pre-trial has been received late, and the pre-trial will not happen today.
Yeah, but they tell a lot of them that they are going again. I'm not pepper, I'm not talking about get all these changes in the television channel, and I'm not in the water get into our video after the end of the start. And maybe I come out with the
Accordingly, the matter will be postponed to 14 May 2026, on which date is envisaged that the pre-trial in this matter will be heard. court notes counsel for the state's undertaking to furnish the finalised section technicians to the police.
manje siyana kufanele ukuthi lokhu kuyavumelana ngako ke imininingwane evumelana ngayo makayilungisile ebhalile ukuthi-ke khona ukuthi-ke yena ummeli wakho naye ummeli wakho-ke abe nakho lokhu-ke uphakathi lokhu-ke okudingekayo umshishisi-ke anako.
You are to remain in custody.
Manje ke uzophilela ngaphakathi njengoba-ke ubuye-ke uyemakhaya.
As the business matter.
As the court pleases, my lord. Thank you, my lord.
Mr. Mungwani.
Yes, he's down here.
He's down there.
Yeah, he's coming up. Yes. As the court pleases, my lord, I'm calling the matter of the state versus Sabelo Mapalala, case number 86/2025. My lord, this matter was remanded for pre-sentence report and probation officer's reports. However, pre-sentence report and probation officer's report.
And the what? Sorry?
Not and pre-sentence report and victim impact reports.
Yes.
However, my lord, the pre-sentence report is not ready, and also the victim impact report is also not ready. We therefore request that this matter be remanded until the 19th of May.
The 19th
of May.
And Mr. McGrath, you confirm the date?
I do confirm the date, my lord. Are you suitable?
Mr. Kumalo, please advance the accused. We are still awaiting the pre-sentence report and victim impact report, and accordingly the matter will not proceed today.
Matlala likhuluma lethu Mosa. Jaanong khankiye fa musisi fa tsanya fa go motho ka mora go fa di report di report le di tsona ga ha e se di siameng le ga di fotse di ko ka jaanong seo se ra gore ga molato wa go ona ga o ka se tswe di o tlo tshwanela gore o busetse morago ka gore ntse go emetse di khamtseya gore di bankanye.
This matter is postponed to the 19th of May 2026 and is to remain in custody.
Molato ga o buseditse morago ga nne o tla boa gape ka go tla go seketsa ka di 19 tsa May teng mo jarete jaaka ga o tswa o le ka mogare o tlo busetsa ka mogare.
Thank you. The matter may stand down.
As comes, my lord.
As the court pleases, my lord.
May I draw the court's attention to case 17 of 2026, State versus Pillay Akpen. Akpen Pillay in custody. My lord, I'm informed by the court orderlies that the accused has not been brought to court. It's supposed to be his first appearance in this court.
But he's not downstairs in the cell.
No, according to the court orderlies, he's not downstairs in the cells. To the 14th of May. That's correct, my lord. We will endeavor to requisition the said accused.
Data, thank you for your appearance in the matter. And will please inform Mr. Mseka of the postponement date.
I will do so, my lord.
In the absence of the accused, where the court is informed was not brought to court, the matter is postponed to the 14th of May 2026, and he is to remain in custody.
As a copy, please, my lord.
As copies, my lord.
Thank you, Mr. Matlala. Your motion will stand down. Thank you, Ms. Levy.
My lord, so the matter is again today before court, and of course that is case number 98 of 2025. The accused are before court. So the matter is again today before court with regard to the request for further discovery and to address the question of the pre-trial. So there's a few. Yes.
What about the pre-trial? The pre-trial's been conducted.
Yes, that is correct. So, but there was an issue with regard to the pre-trial of accused number 5, where they had to submit representations to the national office before a certain date.
Yes.
Yeah, so there has been a change in those plans.
So I think let me first hear. Give me a moment, please. I don't have a note of the court having made any order with regard to accused number 5 making reps to the NDPP by a certain date.
I've got a date of the 30th of April. Be that as it may, doesn't matter. So I was contacted by Ms. Mpombi, Dina, the instructing attorney, who said that they were planning to address head office with representations, but they decided to follow a different protocol, and they would first want to address it to the DPP here in Johannesburg. So those representations I've received this morning. I've said to her I'll make sure that it will get to the right channels before that. So my lord.
So just to help me understand, you received representations.
Again. So the previous representations that was directed to the prosecuting team, that was dismissed by us, me and Advocate Ngubane. Now they wish to go to a higher authority, to the DPP's office, in other words, my direct line manager. And that has been received this morning. So obviously that will need to be reconsidered. Obviously I've not been able to go to Mr. Sakata's office and hear what is his availability in the next week or so, but I don't think it should take that long to decide. That's the one issue. Secondly, for accused number 1, I see Mr. Khadebe is today here. The court will remember that Mr. Gissing was appearing for accused number 1 previously. I was in telephonic conversation with various counsel in the past week or so, and my lord, Mr. Gissing indicated to me that if he does not further see his way open to appear, he will let me know. He has not done so, but I've been informed by his instructing attorney that Mr. Gissing is no longer part of the defense team for accused number 1.
Where is the attorney?
Mr. Gadebe is present here.
Mr. Kadebe. You are the instructing attorney for accused number 1.
Indeed, so, madam.
Yes. So is that correct that Mr. Hassan is no longer the instructed counsel instructed to deal with the defense of accused?
That's information I received yesterday, madam.
But you are going to just say you're going to go.
So, can I just inquire, are your plans to appoint another counsel, or are you going to do the trial, or what is the position?
Well, the commitment, my lord, I can make at the present moment is that we are going to look for counsel, but in the event that we don't find any suitable counsel for this matter, I'm going to run the matter myself, my lord. Mr. Godfrey, madam.
So, my lord, I would like to address the court on a few issues. I just want the court to have it in your mind when I... So, firstly, the further discovery, which is mostly being complied with, 90% has been provided. Then, with regard to the trial date, is the second issue. Thirdly, my lord,
I'm just, yeah, give me a moment. Please.
Sure.
You're speaking specifically about the request in respect of accused number 3.
that is correct, sir, my lord. But your lordship will remember that the other accused were also like riding on the request. Yes. So, and I've kept the counsel up to date with regard to the progress that we've been able to make. My lord, then a third aspect.
You mentioned about the trial something.
I will come back to that, my lord. Then, with regard to your lordship will remember during the first appearances, your lordship brought it to the state's attention that there were certain listing in the charges that did not quite add up to
Yes.
yes. So that prompted us to have a relook at the charge sheet,
Indictment.
and it's been corrected now. So I will take the court through it. It's not major changes, it's just a few minor amendments. The defense has already been provided with this updated indictment, so I will get back to that. And then the last issue that I would want to address the court on is an issue with regard to the reporting by the media on this case. So those are the few issues that I want to address the court.
Yes, if I can interrupt you, please. Do the defense have an issue in respect of the amendments made to the indictment? Counsel for case number 1. Is there an issue with the state's amendment to the indictment?
At this stage, we have no issue.
Yes. According to my recollection, it had to do with numbering and
It has to do with numbering, and then there's a word or a phrase here and there which I adjusted. So it's really stylistic changes.
So you started the indictment, the amended indictment, and you have.
Well, I received it this morning, but if there are any issues, I think it's issues we can fix well outside court.
May it please the court, my lord. Maybe my learned friend can just indicate for us if she says she amended words where it is, because I also have not had an opportunity to peruse the indictment and satisfy myself. And I would hate for my client to be prejudiced by me just saying, oh, I've got no issue with it. If the amended wording, and we all know words can have great effect down the line on issues. So maybe we should start with that, and then I can address the court on that issue. May I please?
So, my lord, and I can hand then to the court the originally, because I had it re-signed also. I re-signed the new indictment, and I flagged it for the court's convenience in blue. I've underlined in red the changes. Underlined in red, all the copies should be underlined. If the court would like me to take the court through the indictment now, I can do so. My lord, if the court can turn to page 2 of this latest signed indictment, the court will note what I've now done is I have, in fact, where the counts are listed. In the previous indictment, for instance, I would indicate that there were 3 conspiracy charges. I actually now also specified which counts in the indictment does it refer to, just to make the reading of it easier.
Yes, but from my reading, your oh yes, I have that. Okay, so count 1 is due. I'm expecting all the counsel to have this in front of them and to follow. Yes, so paragraph 1, if we can call it that, appears to be in order. Okay.
Yes. So I've done it then with all the counts from page 2 and up to page 3. All right. So those are the changes that I've underlined there. I think it's quite clear.
Yes, but if one looks at paragraph 3,
yes,
in the original indictment,
yes,
unlawful possession of a prohibited firearm, a fully automatic firearm, 1 count.
yes.
But
So
in the amended one, it says count 7 and 13 to AK-47.
that's correct, so my lord. So that is that was changed, because when I read through the indictment, I realized that even though in the body of the indictment the charge was phrased correctly, in this listing it was not indicated correctly. So I've changed that now. So the court will see that count 7 and 13 relates to that paragraph referring to the AK-47.
So it's not an addition.
No, my lord, it's not an addition. It's just a correction. As I said, in the body of the indictment, the charge was phrased correctly, even though it was not indicated.
Obviously, look, not that you are not allowed to amend and add, but
Yes.
at this stage.
I just want to keep everyone on the same page.
Yeah,
Yes.
and we all want to understand.
Yes.
Okay. So it isn't an addition.
No, it's not an addition, my lord.
It's basically explaining it better.
Yes.
Yes, thank you.
Then, my lord, paragraph 4 refers to count 23, and that is a change.
Just repeat, please.
So paragraph 4 on page 2. So count 23, again in the body of the indictment, referred to a firearm of which the serial number was obliterated. That is how the charge was phrased. but I incorrectly, in this listing, referred it to under section 4A, 41A instead of 41F. So I just changed the reference to the charge in this paragraph.
Yes. So basically, not 41A, but 41F4.
That is correct, Sir My Lord. Then turning over to page 3, paragraph 5. Again, my Lord, I've just clarified to which counts.
Are you talking now about paragraph 5?
5, did I say 4?
No, you said page 3.
Page 3, paragraph 5. Yes. The court will see that I've underlined the counts now, and I've specified the counts relating to that reference.
But that in the old indictment was paragraph 6.
It could well be, my Lord, but the paragraphs have changed now. So similarly, my Lord, the next paragraph, paragraph 6, again, just specifies the money laundering charges. And then what was left out in the old indictment, erroneously, my Lord, was the reference to the fraud charge. That's why the court indicated to me that it doesn't quite add up, the numbering doesn't quite add up. So I've added the fraud, the reference to the fraud charge.
So that's basically an addition.
It's not a new...
Well, it's...
The fraud charge was phrased in the indictment. It was just not listed in this introduction. It was there.
Yes. So it's not adding of a new charge.
No, my Lord. There's no adding of new charges.
In all the amendments.
Absolutely not. Then, my Lord, with regard to the conspiracy to commit murder charges, again, just the changing of the wording, and the court will find that on page 4, page...
Under count 1.
Under count 1, page 4. So it's now changed to, instead of on or about, I've just changed it to on or about the period leading up to the 10th of August.
Okay.
So similarly, my Lord, the court will find the same amendment on page 6, count 9.
One moment.
It should now read on or about the period leading up to the 17th of October 2023. And then similarly further on page 13 in relation to count 19. Again, it should read on or about the period leading up to the 29th of January 2024.
So there's more specificity in respect of the time period.
Indeed, so my lord, I feel more comfortable with that wording.
Can we just go back to page 12 of the new indictment?
Yeah, I was going to get to page 12 now.
Okay.
Page 12 refers to the fraud charge, my lord, and there I've added a paragraph that starts with the words "and thereby," and I've underlined it, and thereby attempted to induce the courts, the South African police and all, to accept that the money so paid was for a lawful purpose with the aim to create a defence and either avoid arrest or prosecution, or to, after the arrest of accused 3, to be granted bail during his bail application in the Alexandra Magistrates Court. That is the totality of the amendments to the indictment model. So if I may suggest to the court, if the court can then just draw a line through the old indictment and maybe just indicate on the new indictment that it is that, just to obviate confusion in the future for anyone who handles the files.
My lord, I think the correct way to do it is my learned friend to say that she withdraws the previous indictment and she wants the court now to take the new one as the indictment to stand.
Fine. The court will simply write on the red pen on the new indictment, and draw a line through the old ones.
As the court please. My lord, then the aspect with regard to the trial date, I've engaged with the legal team, and what I can recall is that the previous dates that were raised in this court was arranged around the diary of Advocate Gesang. And if I recall correctly, there was a first date arranged from 20 July to 7 August. And then he said he wasn't available for the rest of August, and then there was a date in September, something like that. He is no longer here. So August effectively now becomes available. My lord, I think it is in the interest of all parties that, and that would be my request, and I've checked it with the role planner, even though the date that he gave me this morning was the 31st of August. That is the date that he gave me. I went back to him and I said, August is now available. Can we take August? And he looked again at the diary and he said, it is indeed suitable. So my suggestion, my lord, would be the 3rd of August. I know there will be unhappiness because apparently, and I rely on my co-counsel who also reminded me of that the date that was arranged apparently in this court was the 20th of July. Yes. I don't know if the court made a note of that, but be that as it may, the state's request is, and I think it's in all fairness, that we all have the opportunity, we still need to consider the representation by accused number 5. Accused number 1's position with regard to counsel is still uncertain, so I don't think the 3rd of August is an unreasonable request from the state, and that would be my request. But of course we are in the court's hands, and I'm sure my learned friend will address the court on that. Then with regard to the further discovery, my lord, there is really literally...
One moment.
Sure.
What do you think of my argument? Do you agree with me?
So, my lord,
You were speaking about the request.
yes, that's correct. So, my lord, there is literally still 4 or 5 aspects outstanding, and the state is not unwilling to provide it. We just had a delay. I was in fact on the phone this morning with an official from Sanral to arrange a consultation for tomorrow if we can get out of court earlier. But what is still outstanding is, and I can take the court to specific paragraphs. I know the document may not be before you, but
The document was handed up, but I did not even read the document
yeah, my
for
lord,
the
it's not-
following reasons.
It's not necessary for your lordship to go through it. All I can say is I can literally refer to paragraph 34, 35, 41, 42, and 44 of the request.
So
We-
are you saying that we have complied, or the state has complied with the request?
Yes.
Save for paragraph at this stage.
Yes.
Paragraph 34, 35, 41, 42, and 44.
That is correct.
Okay?
So, and we are in the process to comply with that also.
With,
What we
with
could
all of them.
What we could provide, we did. There are certain aspects that we don't have. We don't have that information. Or maybe it would be better to say, with respect to a request for AVLs, that information does not exist.
This is not correct.
It does not exist.
Which paragraph is that?
So, my lord, if your lordship will just give me a second. Paragraph 29, my lord.
But that wasn't referred to as one of the...
No, that information does not exist, so the state is not in a position to provide something that does not exist.
What is that information about?
So it refers to, and I'm going to read the request to your lordship, with reference to A74, which is the arresting statement of accused number 3, the state is required to disclose the ABL records of each and every police vehicle involved and used for the arrest and or later detention of the accused and or present at the arrest and or called to the scene of the arrest. Said ABL should include but not be limited to the day of the arrest from midnight to midnight. The ABLs of each and every police vehicle present in and around New Road, Midrand at the time of the arrest of the accused. The area should cover 1 kilometer and an hour before or after the arrest. My lord, this is, in Afrikaans is a saying, so wyd soos die Here se genade. But apart from that, I
What
consulted.
does that translate to?
As wide as God's grace.
It's wide as God's grace. So
Wishful thinking.
I really think that the state is not unwilling to provide. We have provided a lot, more than what is in the police docket. But it should also be reasonable. There must be some limit to what is requested. And I've consulted, and I was informed by the team that the vehicles that were used don't have ABLs. So that is the information that I have. Apart from that, my lord, we have complied as far as possible with the request, and I think we've leaned backwards to accommodate the defense team. So, as I said, We are still working on the last few aspects, and it should be able to provide it, I would say, by the latest next Friday, which is the 15th of May. I know we're out of time. We should have provided all of this on the 7th of April, but my Lord, life happens, and we really tried, and it was difficult to get some of this information.
So when you say that you intend to provide, and hopefully will do so by the 15th of April.
May.
I mean May. Are you referring then to paragraphs 34, 35, 41, 42 and 44?
That is correct, sir.
Okay. And what, and apart from paragraph 29, which you say does not exist,
Yes.
is that the only, is the court to understand that that is the only issue in which there cannot be compliance?
There was another aspect, my Lord, where they requested a statement made by one of our witnesses, apparently to IPID, and we are not in possession of that affidavit. We don't have it. And I know, my learned friends came to refer to case law and say, but the state is not just the prosecution team. I am well aware of that.
Well, I want counsel to understand now that I am not going to entertain any application at this stage for the following reasons. It was arranged with all counsel and the court that by a certain date, I think it was the 7th of April, the state would furnish the defense or at least respond to accused number 3's request. Should counsel for accused number 3 not be happy therewith, an application would be brought. The state would then answer, counsel for accused number 3 would reply, and the matter would then be argued. The court heard nothing from anybody, neither the state nor the defense counsel. The court received no documentation from either the state or the defense counsel. So the court was under the impression that everybody's happy and today would be a day where we postpone the matter to the trial date, which appears not to be the case. But I'm speaking about the happiness of the respective parties. So this court cannot be ambushed into now dealing with an opposed application today on certain aspects. You've seen what my role was like this morning, and I have not, in light of the fact that I received no notification or documentation, I did not have the ability to plan my role around the application, which ordinarily I would have done had I been aware that there would be an application. If there is going to be an application, we'll find out. But and I don't believe that the court is being unreasonable in that regard.
Of course not, my Lord.
Yes, thank you.
My Lord, then lastly, the aspect with regard to media reporting.
Yes.
It is quite sad that I have to resort to these measures, but on the 19th of April 2026, the Sunday Times published on their front page a media article quoting verbatim portions from one of the police dockets in this case. Police dockets which is not supposed to be in possession of the media. Not only did they do that, they published a photo of one of my witnesses on the front page in relation to the police docket. In fact, I just want to correct myself, of more than one of the police dockets in this matter. So the Sunday Times went as far as ventilating aspects in the media that's not been ventilated in an open court yet. And I was always under the impression that Media Law 101 sort of explains the sub judice rule to journalists. So we were deeply concerned, and of course this witness was extremely distressed. So we had to do damage control. Yes. My Lord, this is unacceptable. So I want, while the media is present here, and let me make it quite clear, we as the prosecuting team and as representatives of the NPA embrace media, free press in a democratic society. That is why we've got media liaising officers at our office, and that is why we've always maintained an open and friendly relationship with the media. But this was unexpected and uncalled for. At no stage did the Sunday Times approach our media liaison office or us as the prosecuting team just to give us a pre-warning of what they planned to do. So, my Lord, I would ask this court to, I think, once more lay down the rules of media reporting in this matter. Whatever is said in this open court can be ventilated to their heart's content. But to publish, and we still can only speculate how copies of my police docket, of our police docket, came into possession of the press. But be that as it may, the damage has been done, but we would want to prevent further damage. And we would want this court, I would implore on this court, to make a ruling now that nothing that has not been ventilated in open court may be published in relation to this case, as the court pleases. My Lord, that is the extent of my address.
May I please call? I'm so sorry, my Lord.
I'm calling on Mr. Hadidi.
I just wanted to ask the court, maybe, I see it's 11:20, if we can take a short tea adjournment.
Yes, sure.
That would just give us all an opportunity just to discuss the issue of the indictment, etc., with the clients, if my learned friends are so inclined and agrees
Yes, well,
with me.
okay,
If the court has no objection, please, my Lord.
So in regard to the fact that this was handed to you this morning, as I understand, you obviously need time to discuss it with your clients as well as among yourselves. You're welcome to. And at the same time, you can discuss the other issues which have been raised by the state. Can you give the court an indication of how much time you need?
I would suggest, my Lord, us speaking for all my learned friends, half an hour, if the court would be amenable to that.
That's fine. It is now 21 minutes past 11. Let us make it at 12 noon.
That is a good
40
time.
minutes.
Thank you, my Lord.
Okay. Okay. The court will adjourn until 12 o'clock.
All right.
basically, the court just wants to hear if you have anything to state regarding, firstly, the amendments.
As far as amendments are concerned, my lord, I have nothing to place on record. Well, at this stage, there aren't any issues with the amendments made at this stage. However, my lord, I'd like to revisit my earlier submission as far as Mr. Gesing's position is concerned. He called me, and I'm the one that had insisted that we see you during the lunch break, or rather the tea break. But however, I was told that you had preferred that we all come together. But I thought, well, to save everyone time, I must just put this on. I may just put this on record now.
It's not short. Look, you are very welcome to come and see me at any time. However, you need to come with counsel for the state, because the court can't be seen to be having a meeting in chambers with counsel for the state only without the defence, or with defence counsel without counsel for the state. Those are just ethical policy rules of professionalism.
Yes.
But you are welcome to come and see me at any time.
I appreciate that, my lord.
With the state.
As God please, my lord. However, Advocate Gesing has confirmed that he is not available on the 20th of July, and well, he is only available on the 31st of August until the 18th of September, and these are dates that already were confirmed on the previous occasion. So he's not only is not available like the whole of July. He's not available, and he's not available the whole of August, except for the 31st of August. So the 31st from the 31st of August till the 18th of September is available, and then he gave me further dates should the court, or rather should we need more time. And the further dates are...
Yes, before you give me the further dates, sorry, I was under the impression that basically you had terminated his mandate.
That's not the case, my lord. So the report that I received yesterday was from another attorney, say Advocate Gesing, well, won't be attending court and is not available. Then I had to ask, is he gonna come any further? And then I didn't find joy. I didn't find joy on that.
Okay. I hear you, but obviously you need to take into consideration all the other accused. We arranged the trial date in the course of the pre-trial, and notwithstanding his now alleged unavailability, that negatively impacts all the other counsel, all the other accused. I understand that counsel for the state has also made a submission, which I will hear the other counsel on, that the matter starts 2 weeks or so after the set trial date, which I personally have an issue with. Not that this court is going necessarily to be allocated to deal with this trial, but the fact is that one can gauge that this is going to be a protracted trial. And obviously, the sooner the trial starts, the better. Also, in the interests of justice, the interests of the accused who are in custody, and not the interests of justice don't only include the accused. The interests of justice include the interests of society, the community, the victims, the witnesses who need to get their evidence testified to and their appearances over with. And of course the state, the administration of justice, that trials proceed and conclude. So what you're basically asking now, if I'm correct in understanding, is that you wish your counsel, that specific counsel, to deal with the matter, but he's only available on the from the 31st of August until the 18th of September, and then for a certain period thereafter.
Precisely, my lord.
Let me hear what all the other councils say, but not inclined to agree there to because of the protracted delay. And I mean, as you indicated, you can find other council, competent council as well. Alternatively, you indicated that you would do the matter yourself.
Myself.
So, but thank you for that. Then I wanted to just ask you,
26 October.
do you have anything to state regarding the reply by the state to the request that was furnished specifically on behalf of accused number 3, as I understand, but basically which all council sided with or adhered to, whatever the correct term is?
No, none. None, man. None, man.
From Miss LaRue, just correct me if I'm wrong, or if I'm right. There were 4 aspects you raised. The first aspect was the amendments.
That's correct, my lord.
The second was the issue of specifically Mr. Hassan and accused number 1's representation.
That's correct, my lord.
Then there was the issue of the reply, the reply to the request for documentation,
That's
etc.
correct, my lord.
And the last issue was the issue of the media.
That is correct, my lord.
Those were the issues.
That's correct, my lord.
Yes, thank you. Thank you, Mr. Hadebe. Mr. Kruvier, can I hear you on
May it
those?
pleases the court, my lord. In as far as the amendments to the charge sheet are concerned, I have no issues with that. The particular charge that has been substantially amended relates only to accused numbers 3 and 4. It does not affect me. I do, however, have an issue with regard to the trial date. We have previously arranged the date of the 20th of July to commence with the matter. I have cleared my diary from then onwards in order for us to deal with this matter efficiently. We have another trial commencing on the 26th of October, so we need to try and finish this matter long before then, and I will therefore request that everything be done in order to ensure that the trial starts on the 20th of July or as soon as possible thereafter. In as far as the request for further particulars are concerned, I understand that certain information will still be supplied to us by next week Friday, and we will approach your lordship with regard to an application for further particulars if all the particulars requested are not provided. Timeously on a date to be arranged today if possible. We have in mind the 26th, 27th or the 28th of May to deal with any such issues with regard to further particulars that has been requested that has not yet been supplied by me. May it please the court.
May it please the court. My lord, the as far as the indictment is concerned, there is. I'm not going to raise any issues about the indictment. The state is always entitled to amend indictments, even during the trial. I have, however, taken note of the fact that there were quite substantial changes in some of the charges relating to us. But I'm going to move on from there swiftly.
You are well aware that
even during trial, you can.
During the trial, while evidence is being there.
Indeed, my lord. So that's why I'm saying I'm not going to make. It's just a pity that it happens at the eve of the trial, or so short before the trial. But be it as it may.
These are not. I don't believe these can be categorized as extensive amendments.
No, it's
that will impact on that you are going to need another week to consult on or anything of that nature.
Might need another week to do research. Just a joke. My lord, the issue that I have is as regards the trial date. Your lordship would recall that on the last occasion when we were in court, I think it was the 18th of March, the issue of a trial date was raised, and at that point the matter stood down at one stage and Mr. Gissing was contacted. The state was the state also phoned the person dealing with the book. I think there's a new person currently dealing with it, and the suggestion then was...
Are you referring to the role plan?
The role planning, yeah. Everybody then agreed to be available from the 20th of July to the 7th of August. Your lordship would recall, I can't remember if I placed it on record, that I have some issues with the trial date, but I'm going to rearrange my diary, which I have, to make myself available. The 3 weeks in between, the 7th to the 31st, was cut out because of Mr. Gissing's non-availability at that point.
Of August.
Of August, indeed. And the matter was then to commence again on the 31st to the 11th of September. My lord, my instructions are that we're going to insist that the trial commences on the 20th of July. This is, I couldn't have summed it up better than your lordship did yourself. This is, it attracts a lot of attention, this matter, and everybody has an interest in this matter for a variety of reasons. My client is entitled to a speedy trial, and that's what we're going to ask the court in force. I've got a further suggestion, my lord. Since Mr. Gissing is clearly not available to do this trial, I'm going to ask that we then also utilize the 3 weeks in between. Because it was cut out for his
specifically to accommodate him.
It was only to accommodate him at that point. That we then utilize those 3 weeks and we let the trial run. The quicker we start and let the trial run, the quicker this matter can be finalized. So that, in fact, would make a 3-week difference in the running of the trial, and I think it's 3 weeks that we should utilize. If he's
well, it's a substantial period.
Indeed, my lord. So, as far as the trial date is concerned, my lord, my instructions are that we're going to request the court that the matter indeed commences on the date that everybody said they will be available and the trial would run. But we're asking one further. We want the court to also include the 3 dates, that substantial period in between. Then, my lord, the next issue pertaining to the disclosure. Your lordship is quite correct. There was no application served in this period because we've been intermittently getting disclosure by the state. So the cut-off date for the state was the 7th of April. On that date, there was partial disclosure. The 4th, that is past Monday, we again got disclosure. And as your lordship would have heard this morning, there's still issues that's outstanding. So we were not intending to bring a piecemeal application in this regard. But I can tell your lordship, based on some of the answers that we so far have received, we intend to launch an application to compel the state. If I can just touch on 2 very brief issues, my lord, and I think it's good that we just quickly ventilate them. It's the issue of the AVLs. My lord, it's almost trite that all police vehicles are fitted with trackers. I've been in many trials where we've subpoenaed the service provider, and they've provided us with it. They even go so far as to they can tell the court if a tracker has been switched off deliberately so that the movements cannot be tracked. So to say that there's no trackers, I absolutely do not believe it. Police vehicles, as a matter of course, are fitted with trackers. And there's good reason why they're fitted
But
with
those
trackers.
things will obviously be
Indeed.
ventilated. in
So I'm
the
just saying,
application.
I'm placing this on record so my learned friend can take note of it. Even what she said, the issue that is so wide, my lord, it's a simple thing. They have a computer, I've seen it myself, from the service provider. And you go to a specific address and you say, do a kilometre, and they go a kilometre and they can pinpoint every police vehicle that's in that area. They do it on a computer screen because that's the program. So it's a very simple thing to get us an answer to our question. You speak to the service provider, you tell the service provider what we need, and he will be able to supply it. The other issue was the AVL, so that we've dealt with, and then the issue of IPIT, the complainant statement that was with IPIT. My lord, that issue was ventilated in the public domain, in the press. They quoted from it, from the statement that was made, where the witness, Tovajani, specifically said that she was assaulted and forced to make a false statement in this case. So my learned friend...
Are you speaking about the Sunday Times article?
No. It's the statement that she says, the IPIT statement that they don't have. Now, if the press can get hold of that statement for some inexplicable reason, I can't see why my learned friend can't get hold of the statement to disclose it. My lord, if you can just please. In fact, my instructing attorney says on the 14th of September last year, there was a whole article published on this particular issue in one of the dailies. It related to the IPIT complaint, it related to the complainant, what she said to IPIT, and even the name of the instructing attorney in that matter was published. So it's out there in the public domain. So again, I just want to make it clear so my learned friend understand, to say that you can't get it, it just doesn't wash with us. Then the issue, my lord, pertaining to the reports by the media, I hope there's no veiled suggestion that the defence has leaked the dockets to the media, because we're not in the business of leaking dockets to the media. It's not in our interest to do that in any event. We like that. Part of our job is to catch people by surprise. So there's no reason for us. We can gain no advantage by leaking any docket to the press. Then, my lord, the last issue that I wish to touch on is the following. On the last occasion when we were in court, my understanding is that the detention warrant was signed, and it clearly indicated that my client, that is now accused number 3, would be detained at Vusimuzi. My understanding is then that the court orderlies were called back by the state and told to change the detention centre to Kokstad. It was then changed and he was moved to Kokstad. It's not, I understood
So
my...
is accused number 3 currently being held in Kokstad?
No, he was subsequently, IDAC moved him back, and we've got a court order now that he's been detained in at Vusimuzi. But I just want to make it clear for the record, that the detention warrant was clearly today state that he goes back to Vusimuzi. It's not within the state's purview to take the detention warrants that's been signed and change the place of detention. He is currently, by virtue of a court order, to be detained in Vusimuzi, and we want to place that on record. May I please the court? I've got nothing else. Thank you, my lord.
Which court ordered this?
The Pretoria court ordered this, and it was agreed to at that stage by both IDAC and seemingly the prison authorities had no issue with it either.
Is that the High Court or not?
No, it was in the Magistrates Court itself. But Lord, in any event, I mean, I think it's common cause that our client is also involved in the Matlala Commission, and for that reason, he's also being detained here. So the point I'm just trying to make is the client's detention warrant must be signed and clearly reflect the fact that he's going back to Vusimuzi, and not behind our backs being changed again to take him off on a wild goose chase to Boxer. May I please?
Thank you.
As the court pleases. My Lord, we do not have an issue with the new indictment, and I think that's where we need to start. We do not have an issue. And I share the sentiment by my learned colleagues that there was a date that has been arranged, which was the 20th of July, and that we should keep to that date. Though my reasons obviously would be different from the reasons of raised by my colleagues. Our reasons are: accused number 5 is a student. She's studying, and she has to go through exams. This matter is emotionally and psychologically affecting her studies. And again, that is where one has to employ the principle of justice delayed is justice denied. And it is for that reason that I'm going to share the sentiments echoed by my learned colleagues that we keep this matter to the 20th of July and we finish this matter. There are issues that I don't want to get into now, issues that will be ventilated at a later stage in a proper forum, and even if it is before this honorable court, but I think at the right time we will then ventilate those issues. If it won't be before this court, it will be ventilated at the
trial court.
In the trial court. It might not be the trial court, but whichever way, when that appropriate time and forum avails itself, we will then raise these issues. As the court pleases.
If I can just ask you, and I will come back to the other counsel, Ms. van den Heer's suggestion or proposal that the trial further proceed in that period that was initially excluded because of Mr. Christen's unavailability from the 7th to the 31st of August.
We are available and we are ready to proceed during that period. As the court pleases.
Thank you. Mr. Hadebe, what do you say about that period? Obviously, should you yourself do the trial or you obtain the services of another counsel, it makes sense, does it not, that the trial proceeds?
Well, my lord, it does make sense, but however, I'm a creature of instructions, and if my client has a counsel of his choice, right, because this is not a minor matter. It's a very complex matter, and it requires a certain skill. And if there's a certain counsel that my client prefers, and the counsel is not available on that date,
Yes, but
My
it's not
client-
only that date. The counsel isn't available suddenly when the trial's supposed to start. So must the court shuffle around everything?
That's all. I'm not suggesting that, my lord. However, if the court is inclined to stick to the 20th of July, then it seems that it's a problem that we have which we must fix with our own counsel. Because these are dates that were agreed upon before we could actually do the pre-trial, and then we actually did the pre-trial and confirmed the same dates. It's a problem that we'll have to fix ourselves. But however, if already then dates are shifting, then it creates a bit of a problem even for me personally, because cannot say to my client that I had to take a date because everyone agrees to that date. If say I'm not available, or rather my counsel is not available, and my client says this is the counsel that I prefer, right? What else can I do? My hands are tied. But however, at the end of the day, the court can make a ruling. Right? I can only make a request before the court, and the court can tell me that okay, or rather can order that these are the dates that the court deems to be suitable. We're looking into the fact that they are accused that really, after this matter could be released. Well, my client is in custody for another matter. Hence, I can take the 31st of August because anyway, he's still in custody for other matters.
But just on one note, the court did not determine the trial date. The trial date was determined by counsel.
That's correct, ma'am.
Yes, thank you.
It's correct.
Mr. Crivier, what do you say about...
My lord, just a second. I beg leave to approach my client.
Yes, sure.
Well, my lord, it is my instruction that I actually stick to the 20th of July, to the dates that I initially committed to during the pre-trial. That's the court, please, ma'am.
Yes, but when we talk about the 3-week period, are you in agreement that that 3-week period was specifically
To accommodate Mr. Hussein.
Yes,
That's true.
and the fact that he's not available to start the trial, and the fact that, as you've indicated, your client's instructions are now to proceed with the trial, that, am I correct in understanding that there shouldn't be a problem, that the trial proceeds from the 7th of August as well onwards?
Well, at my client's instance, there shouldn't be a problem. Scott, please, ma'am.
Excuse me, Mr. Riviere.
As indicated, my lord, I'm available from the 20th of July onwards, and those dates in August is also suitable to me. May it please the court.
My lord, I clearly forgot, if your lordship would just bear with me for a second. I want to suggest, when it comes to the issue of the further particulars, that I've canvassed it with my learned friends. I didn't have time to canvass it with the state, that we utilize 26, 27, 28, somewhere there to bring an application to compel me. My learned friend would say that her last documents would be available by the 70, I think it's next Tuesday, which then gives us ample time to launch an application and for the state then to respond thereto. I think the quicker we deal with these issues, because we then by the end of May already, so it's June basically before we start running with the trial. That gives us enough time.
I can just indicate that these dates are not suitable to the court.
Can your lordship maybe indicate to us suitable dates, and if our learned friend can then also just indicate to us.
Yes. Okay, thank you.
May it please the court.
Ms. Levy, can you first deal with the issue of the trial date?
Yes.
You indicated that it would be more suitable to the state
Yes.
to proceed in August.
Yes.
As the court has indicated to counsel, you have the trial date was set, not by the court, but by counsel.
Yes.
And unless you can convince me not to proceed or not to keep the trial date as set, I'm not inclined to change the date.
Yes.
And especially in light also now of all the counsel being available.
Yes. Now, my lord, we will obviously
Make arrangements.
and communicate that to the role planner.
Good.
I've in fact already did that, and he said he can shuffle around a few cases and fit us in, so that is fine.
And then regarding the 7th to the 31st, that was blocked,
That's fine, my lord. It's suitable.
you will proceed.
Yes.
So then the court is correct in understanding that the trial will proceed on the 20th of July and go on.
Yes.
The other issue relating to the press,
Yes.
the court is not prepared to make an order in light of the fact that what you have stated is serious. But you need to bear in mind that these are submissions you've made to the court from the bar. Obviously, if there were to have been an application setting out the policies, the case law, etc., the court would then consider saying. I find it disturbing that a publication such as the Sunday Times, which is a reputable publication, would not adhere to or comply with the rules and the law pertaining to what a newspaper can and cannot print, what they should and shouldn't print. And but what you've advised the court of is basically, well, it's basically a submission.
Yes.
The court knows nothing about this. The court has not seen the article, and the court does not know the facts and the circumstances. But what the court will say is that the court expects the press to abide by and to comply with what it may and may not do in terms of publication. And with all the members of the press in the court expects the respective members to abide therewith. Because there are serious consequences if they do not.
Yes, indeed.
And then, yes, regarding these dates, proposed dates for the application, it is apparent that there will be an application on whatever aspect. So unfortunately, this court is booked out, and especially in, well, until the end of this month. So the court is looking at the beginning of June. When do we have the continuation in the Switzerland matter? Is that in June? Is it
That is the 22nd of May.
the 22nd of May?
That is correct, so my lord, I can just quickly confirm. Yeah, it's Friday the 22nd of May, my lord. I can just ask for the court's indulgence, since the court is going to determine a date in July, whether we cannot determine that date on the 17th of July. We are not available before that, my lord. Our diaries are also booked up. So, and it is something that we would obviously want to give the proper attention to. We will obviously try to...
Yes, but if the application is to be argued on the 17th, that's 3 days before the trial starts.
No, my lord. Sorry, did I say July?
You said
Wrong.
July.
I meant June.
Oh,
My lord,
yes.
yeah, sorry. So that is the state's request.
Yes. Look, that would suit the court. Am I correct that the last day of term is the 19th of June, or not?
It should be the, my lord, let me just check.
Or is it the
It's the 21st of June.
Yes, the 21st of June is the Saturday.
Oh yes, then it's the
So,
20th of June.
yes. So, Ms. Condon here,
Sorry, the 19th of June.
I'm in Cape Town, man.
Friday's the 19th.
Yes.
You gave dates of, well, you gave 3 dates. So what about 17, 18 and 19?
Lord, the problem is we dealing with that big Transnet case, and the judge president, the DJP has also allocated a specific judge to deal with it, and arguments will be heard on the 17th in that matter, and on the 18th there's another appearance for another one of the Transnet matters. So I'm not available on those 2 dates at all.
Okay. What about?
I can do the 15th, my lord. If
are we going to need 3 dates? I don't
no, I
so.
think what
especially in light of from what we have been advised, it's going to be on very limited issues.
Indeed,
So
and your lordship.
what about the 15th and 16th of June?
The 16th is a holiday.
16th is a holiday. My lord, let's do the 15th, and we can do the 17th maybe later in the day if that suits the court, because I don't know how long argument will take before the judge that's hearing that. My attorney, I'll ask him in the meantime, or one of my colleagues there, to sit in the matter for a short bit. If we need to run over, or even here, one of my colleagues can maybe sit in the interim, because we will all do, I assume, separate applications on separate issues. But your lordship knows my applications are normally quite comprehensive, so is my heads of argument, and it doesn't need, I won't need that much time.
We do the 12th. He's mentioned the 12th. It's a
And the
Friday.
12th,
Because
so,
Tuesday is a public holiday. It's going to be.
But from my understanding, or am I incorrect in understanding, that basically you are doing the application?
yes. I don't know if anybody else
And
is
that-
intending to, but I will.
Yes, and that, not that there's anything wrong with it, obviously, but that the other counsel or the other accused are riding, basically, for want of a better expression, on the application in respect of your clients.
My lord,
So it's not necessary for all counsel to do that.
well, what we can do, I can discuss it with my learned friends. If there is specific issues that they feel quite strongly about, I can potentially deal with that, and we can just do one application. We might maybe ask your lordship's indulgence just to break up maybe the argument on something specific. If I can maybe just approach my learned friends. Are you guys happy we do it? Yeah. So the my lord, the 12th is. I'm then happy, my lord, if we can do the 12th and
I thought you said
the 15th. I mean the 15th. Sorry.
the 15th and the 17th.
The 15th and then the 17th if needs
Did
be.
we just ask counsel for the date?
We reluctantly agreed to that date, my lord. The 15th would be suitable.
15th of June.
Push it to the week before. If
No, it's
that
fine, my
suits you
lord.
more.
It's fine. Let's take the 15th.
Okay. Don't say that this court is not accommodating
No, my
or
lord.
attempting to be accommodating.
My lord, I just need to address something before the court.
If you intend to address on the issue of what Counsel for Accused 3 and 4 stated about she sincerely hopes that it's not being understood that the defense leaked these documents to the Sunday Times or anything, you don't need to address me.
My lord, I did not even suggest that.
Oh, okay. Yes.
I wanted to add something now, but I won't. Be that as it may, my lord, with regard to the issue of where accused was moved to on the previous date, I want to make this clear that I wish I had the power to make that decision, but I don't. Because that discretion lies with DCS, the Department of Correctional Services. So what happened on that particular day is the following. The court orderly who was on duty that day approached us and he says he's now confused, he doesn't know what to write on the J7. So I said to him, let me make a call. So I called Mr. Matiba from Correctional Services, he's apparently the regional manager. And he said, you know what, that decision doesn't even lie with me, let me make another call. And then he came back to me and he said, his instruction is that the accused should be moved to Kokstad on that day. And I conveyed the message. I said, DCS said he must be moved to Kokstad. And that is what apparently happened. So if the suggestion is that the state is underhanded or that I have some powers which I thought I did not have, I do not have it. But I've taken note of the fact and I've canvassed it yesterday with the investigating team. We have no objection if this court rules that he is kept at Vusimuzi.
Well, I haven't ruled anything.
Yes, but I the
Yes.
same.
Speaking about the press, one of my colleagues asked me why did I order the accused number 3, just in conversation, to remain in Johannesburg. And I didn't know what he was speaking about. And I said, what are you speaking about? And he showed me a video clip where one of the reporters reported that I had made such an order. The bottom line is that we all need to understand also, reporters, and we respect them obviously, are not lawyers or advocates or trained, many of them are not trained in the law. And often one reads reports or sees something that really did not happen.
That's correct, my lord.
And it's reported on as a fact.
Yes.
Yes, I'm sure Counsel for Accused number 3 has your response. And good.
Thank you, my lord.
Thank you. Is it necessary for the accused to be here when this application is argued?
Yes, they need to be present.
All of the accused.
I don't know.
Is it necessary for counsel, the other counsel to do?
My Lord, who wants to be, like we did it the last time, the only thing that we didn't do right the last time, normally the accused should be present with such a hearing, but I don't mind who's present. The last time, Your Lordship would recall, we broke it up in different days. So I don't know, whoever wants to be present is more than welcome as far as I'm concerned.
No, the last time we ordered that should the application be heard today,
I'm talking about our other matter that we argued in front of your Lordship, the Transnet matter. You will recall that we broke it up and not all counsel was present at all
they were
relevant
all on
times.
bail, weren't they? None of them were in custody.
No,
But
they
it
were
was
in fact
counsel.
on bail, exactly so. But I think it is, just for the record, I don't want an issue with that.
Yes.
And I think my
So,
client would also...
Do you want
I want
both your clients?
My clients need to be present.
Accused 3 and 4.
Yes.
Yes. Mr. Hadebe, do you intend to be here? Do you want your client here?
I can quickly, sorry, my apologies, man. I can quickly take instructions on the beg lift.
Mr. Hadebe?
I will request that my client be here on that date.
And will you be here?
Yes, I will also be here, my lord.
My Lord, I'm going to be also present. My client would like to be present on the day.
My Lord, I've taken instructions, and I also think that in the interest of financial interest, it would be better if we are not here and our client won't even attend.
Very well. Thank you.
My Lord, I'm so sorry that I have to now interrupt your
sure.
train of thought. Something that my colleague raised during the adjournment, and I actually think his argument is sound with regard to the representation, is that when the previous representation was dismissed, it was actually dismissed on behalf of the office of the DPP here in Gauteng. Although Advocate Serepu, who is our deputy, he signed the correspondence. So we're just thinking that I wonder if it would not be more appropriate for my learned friends to direct this representation directly to the NDPP as they intended initially. I just want to place that on record. We're going to canvass it with them, and we just think that that may be a more appropriate approach.
Well, I was about to ask you earlier,
Yes.
because I thought maybe there are new policies, excuse me, policies, procedures or rules. I've never heard personally of representations being made to your office and then being refused, and then they go to the DPP.
Yeah.
My understanding has always been, subject to there being new rules, that once it's refused by your office, the next step is to approach the NDPP.
Yes.
But it's not and I don't believe it's something, unless you want me to order that by X date the reps in respect of accused 5 are made to the NDPP.
I think I'll leave it
Mr.
for counsel.
Francis.
Mr. Chauke.
Mr. Chauke.
Yes. I'm not yet married.
Sorry, Mr. Chauke. Yes.
Yes, the court pleases. My Lord, if the court would have listened to the prosecution initially when it addressed,
Yes.
the prosecution
I did listen.
Yes. The prosecution has indicated that they have considered the reps themselves and they decided to decline. So it couldn't have been the office of the DPP. And it is procedurally correct that the reps would be made to the prosecution and they deal with them, and if they are declined, then we will approach the DPP. But if the prosecution today feels that we need to go the route of the NDPP, and I hope tomorrow we cannot be told that we did not follow procedure, that we have jumped a process, because procedurally, and I know as a matter of fact, that the reps would be made to the prosecution, and once the prosecution declines these reps, then we go to the office of the DPP. And after the DPP has declined, it's then that we go to the office of the NDPP. So if we go to the office of the NDPP and we did not approach the DPP, we might be told that you did not go through the process that you should have gone through, and it might be problematic to us. But
but in short, this does not affect the court. This is something that counsel need to liaise about. I mean, I'm sure it's a matter of a phone call to establish what the correct procedure is. I'm not saying your procedure is wrong. I'm saying this is, when I was in practice, this was the way things worked.
Well,
but maybe it's changed, maybe it's always been that way, but that is what I was aware of.
As the court pleases, I would take your lordship advice that we postpone this matter now. I will be in contact with my colleagues and we would establish what the correct procedure should be from here, and we'll follow that.
Thank you. Good. Okay.
Thank you,
Anything
Michael.
else, anybody? Right. The court then makes the following order. The indictment is amended. The new and amended indictment has been handed up and is placed in the court file. The trial date remains at 20 July 2026 and is to proceed uninterrupted. This matter is postponed to 15 June 2026 and possibly 17 June 2026 for the hearing of an application by the defence in respect of documentation to be provided to it by the state. Accused 1, 2 and 3 are to remain in custody. Accused 4 is on bail. Her bail is extended until the 15th of June 2026, on which date she is to appear in this court, together with accused 1, 2 and 3. Accused 5 is on bail. Her bail is extended until the trial date of 20 July 2026. Accused number 5 is excused from attending this court on 15 June 2026, as is her counsel, Mr. Chake. Have I
Mr.
left
Court,
anything
please.
out?
Nothing, my lord.
Thank you, counsel. Thank you to the court staff.
All right.